Hello and welcome to New South Wales Workers Compensation Reforms Explained webinar. My name is Kristen Harrigan and I'm here from iCare's mobile engagement team. I'm coming to you today from the Central Coast of New South Wales. I'm on Darkinjung country and I would like to pay my respects to elders, people and ancestors of this country where I'm based. I'd like to pay my respects to the traditional custodians of the various lands on which we all work on today and any Aboriginal and Torres Strait people participating in this webinar. In this webinar, we will be discussing some of the detail about the recently implemented New South Wales workers' compensation reforms. But before we begin, just a little bit of housekeeping. To minimise disruptions, attendee microphones and cameras have been turned off. This webinar will be recorded with a link to the recording sent to attendees in approximately 2 weeks. A little bit later through the webinar, we'll open the questions chat box for you to be able to ask any questions you have. We will attempt to answer them, but with just under 4,000 registered attendees, we won't be able to answer every question, but we'll do our very best. Today, I am joined by Matt Beer, Head of Technical Claims, and we thank Matt for his time and expertise on all things New South Wales workers' comp reforms. So let's dive in. Matt, these changes have been discussed since 2025 and throughout 2026. So before we get into all of the detail, can we start with the why? Why are these reforms being made and what are they trying to achieve?
Sure, Kristen. The aim really is to achieve better outcomes for workers and employers of New South Wales by creating a fairer, more consistent system with greater certainty in decision making. That's done by developing stronger alignment between the New South Wales workers' compensation, industrial relations and the work health and safety systems. The New South Wales Parliament made changes to the workers' compensation legislation, and those changes affect how injuries are assessed, how claims are managed, and the support that's available to people who've been injured at work. As you're aware, the New South Wales workers' compensation system provides support to people who experience injury or illness at work, including assistance with their recovery and returning to work wherever possible.
Excellent. And what is our role at iCare? Are we involved in the decision making about what's in and what's out?
Yeah, iCare's role is really about operationalising the legislation to support the claim service providers or the CSPs, as well as employers, agencies and workers to understand and implement those changes.
Okay. So Matt, are you able to provide us with some detail around the current state of play of these changes? Where's it all at right now?
Of course. So there has been quite a lot of activity with the legislation, the regulations and the guidelines. And today we'll be walking everyone through what has been finalised. We'll go through what those changes mean for everyone. Now, from the 1st of July, a number of key changes to workers' compensation legislation have already commenced. And this is off the back of the amendments that Parliament introduced through the Workers' Compensation Legislation Amendment Act in 2025 and the Workers' Compensation Legislation Amendment Reform and Modernisation Act 2026. The supporting regulations and guidelines have now been finalised and they are available on the CIRA website. Now, they include the Workers' Compensation Regulation, the Workers' Compensation Guidelines, and the Market Practice and Premium Guidelines, or the MPPGs.
Okay, excellent. So Matt, it appears that some of the key changes focus on workplace mental health claims, particularly on how the claims are made and assessed, as well as a change in obligations for workers and employers. Can you tell us a little bit more about this?
Of course. So I think last time our iCare colleagues spoke about how there are new rules for primary psychological injury claims. Psychological injury is now defined in the legislation, and it's defined as an injury that is a mental or psychiatric disorder that causes behavioural, cognitive or psychological dysfunction. Compensation is payable for a psychological injury only when specific criteria is met, and that criteria are that that the injury was caused by a relevant event or series of relevant events, that there is a real and direct connection between the relevant event and the worker's employment, and the employment is the main contributing factor to the injury. The legislation introduced definitions for those relevant events, and this distinguishes between trauma-based events and conduct-based events. There are also some differences in the way that claims arising out of conduct relevant events like bullying, harassment, and the way that they're approached. For claims relating to conduct behaviours, there is a new interim entitlement benefit that has been introduced while the insurer determines liability. There are also shared obligations for employees and employers to provide information so that the insurer can make a determination within the expedited 42-day period. The legislation has also been broadened so that what is considered reasonable, to consider what is reasonable management action. So there will be additional information to consider with reasonable management action defences, as the legislation now has prescribed activities such as feedback about an employee's performance as a potential defence.
Okay, thanks, Matt. So I understand there are some additional changes related to the IRC, whole person impairment and premium rates.
Yep. Yes, the Industrial Relations Commission, or the IRC, has now stood up their workplace conduct jurisdiction, and they will hear disputes about whether the conduct that has caused the injury meets the definition of relevant conduct. There's also changes to determine whole person impairment with workers subject to new single assessment rules. Those changes include the requirement for a worker to obtain independent legal advice before they're seen by a permanent impairment assessor. Additionally, the permanent impairment agreement, that results from the single assessment, must be used to establish a worker's entitlement to weekly benefits, medical expenses, lump sum compensation, commutations, and work injury damages. There's also other changes which include a premium rate freeze for nominal insurer employers. That means that the Workers' Compensation Industry Classification, or the WIC rates that are used to calculate premiums for the 25-26 policy have been maintained for a further 2 years.
Thanks, Matt. I'm just having a quick look at the chat box and the live Q&A. So that is now live if anyone has any questions that they would like to pop in. So it's just to the right-hand side of where we're appearing on everyone's screen. If you would like to launch that and ask any questions that you may have, because at the very end of this, we'll be addressing some of the questions. So Matt, it sounds like there are so many changes that are occurring. Will the changes apply to existing claims or only to new claims from a certain date?
That's a good question. So some changes do apply to new claims from a certain date. It applies to claims notified from a certain date. That includes the new requirements for primary psychological injury claims, and it means that those claims will need to satisfy relevant event criteria from that date. Reduced entitlement periods for primary psychological claims that do not meet the relevant threshold, so they are in effect. And other changes that will apply to both new and existing claims include the new test for accessing medical care and treatment. So the reasonable and necessary definition will apply to claims both new and existing. And changes related to the single assessment for whole person impairment means that there will be a limit to permanent impairment assessments that will apply to requests that are made on or after that date.
Okay, right. So there are a number of changes to the regulations that support the workers' compensation legislation. Can you give us a bit more information about these?
Yes. So the final regulations were published on the 26th of June. Firstly, a prescribed death has now been included as an additional relevant event for psychological injuries with defined proximity requirements. So it now states that the prescribed death for a worker means the death of a person in the worker's care if the person dies as a result of a traumatic incident, and there is a real direct connection between the person's death and the worker's employment, and the person was under the immediate and primary care of the worker at or near the worker's workplace when the traumatic incident occurred. There also needs to be a relationship between the person and the worker that was pre-existing, ongoing, and close at the time of the person's death. And the relationship was a requirement of the worker's employment. So there's quite a lot of criteria to be met to satisfy the prescribed death. The second change has been an additional definition of a traumatic incident, and that now also includes an incident that results in the death of a person as a result of an act that is negligent or reckless, and that is not already specified in the Act, like fire or explosions. Another change is the final regulations for determining whether treatment is reasonable and necessary have been updated after consultation. They have removed the requirement that no other treatment or service options exist that can provide similar benefit to the worker at lower cost. The treatment or service must now be provided to the worker with the primary purpose to treat the injury that's subject of the claim. It must be clinically justified to treat the injury that's subject of the claim and be cost effective and represent value for money. The treatment will represent value for money if the costs relative to the benefits achieved from the treatment and the cost of the alternative treatment or service. Some people might notice that the list of treatment or services which an employer is not liable for has been clarified, and now treatments such as GLP-1 medication and cannabinoids are no longer excluded as was proposed. Just a little reminder that the changes to the medical entitlement test to reasonable and necessary don't commence until the 1st of October 2026. And moving on, the final regulations also changed the language proscribing the information that a worker must give when a claim for relevant conduct is made. So you might recall in the initial draft, it indicated that the worker had to provide evidence of their injury. That language has now changed from evidence to information. So the regulations now state additional information required of the worker's injuries caused by the relevant conduct.
Okay, thanks, Matt. Now, another topic that we're receiving a lot of questions about is excess. Can you tell us more about the changes relating to excess and how it'll all work?
Sure. Excess provisions have been confirmed. CIRA has published a fact sheet. It's called the Employer Excess Guidance, and it is on their website. And that provides examples. I think there's 4 examples in there, and further clarity, but excess does apply where the date of injury is covered by a policy that has been renewed on or after 4 p.m. on the 30th of June 2026. The amount is based on the first 2 weeks that a worker receives of weekly benefit payments. That includes the first week that the worker becomes entitled to weekly benefits above $0 and the week immediately after that. That excess amount is the total of those 2 weeks of weekly benefit payments. And just to touch on a few other points, the regulations also state that the NI is to establish an independent advisory service, and that is designed to give advice about the workers' compensation system to both workers and employers that are insured by the NI. I can confirm that that advisory service is already in operation. There are further details about that service, and relevant contact information is available on iCare's website. And finally, the finalised regulation also expanded commutation classes. Now, they now include claims for industrial deafness.
Excellent. Thanks so much for that, Matt. So for everyone, CIRA has published updated workers' compensation guidelines and supporting collateral, including FAQs and some fact sheets to help inform workers and employers about these changes. I would encourage everyone to take a look at the Workers' Compensation Information Hub on CIRA's website, where all of this information can be found. And in addition to CIRA's website, iCare also have a dedicated reforms FAQ page, which provides the links to the regulations and guidelines. And the links to all of these resources will be provided in the post-event email for any registered participants. Okay, so moving on, there's a bit more to recap about these changes to psychological injuries. And we now know that there's 2 different types of relevant events. There's the trauma and then there's the conduct. Matt, are you able to run us through the differences between what a trauma event is and what a conduct event is?
Sure, there's quite a bit to unpack here. So the new psychological eligibility requirements essentially break the relevant events into 2 categories. The first we'll look at is a traumatic event. Relevant events relating to trauma include specific, significant, and objectively traumatic events that cause or are likely to cause death or serious injury. Those events include witnessing or being subject to violence, a serial criminal offence, natural disasters, fire or explosion, a motor vehicle accident, or another accident, as well as suicide or attempted suicide. With the trauma-based events, the worker will have to nominate the event and be able to provide information to support that they meet the required definition for that event. But otherwise, the claims processed for those particular claims remain the same as it does currently.
Okay. And can you then explain the requirements for a conduct-based relevant event?
Sure. So this is where it now differs and becomes new. The conduct-based relevant events include specific and objectively unreasonable behaviour. Now, these include sexual or racial harassment, bullying, and excessive work demands. The decision maker needs to consider what a reasonable person would consider unacceptable, and the worker's view or their perception will only count if that perception is reasonable. Now, for complete clarity, the relevant events are all defined in the legislation and regulations. If a worker has a psychological injury that was caused by something that does not fall within the proscribed list of events, they will not be entitled to compensation. For example, stress or interpersonal conflict.
Okay. Now, moving to the next slide, this is a great recap of what the comparative view is of what trauma versus conduct events are. Can you just walk us through this one?
Sure. Some people might have seen this slide previously, but it's worth going back over because it gives a really good snapshot of the differences between the two pathways for trauma and for conduct-based relevant events. For claims relating to either trauma or conduct, the worker needs to nominate the event and be able to provide information to support that they meet the required definition for that event. If the worker nominates a trauma-based event, the insurer can follow provisional liability pathway. This means a reasonable excuse can be applied to the claim, or the insurer may accept provisional liability for up to 12 weeks. The worker would then be entitled to 95% of their PRW during that period. Now, in circumstances where the insurer disputed liability for a trauma-based event, the internal review pathway is optional and dispute resolution would be through the PIC or the Personal Injury Commission. If the claim relates to a conduct-based event, so that is the bullying, harassment, or excessive work demands, the insurer will have up to 42 days to make a decision on that claim. Now, during this shortened period, the worker will be entitled to what's called an interim payment, and that is 75% of the worker's PRW or their pre-injury average weekly earnings. Now, some early mental health treatment expenses are also available, and that is capped at $7,500. If an insurer fails to make a decision within that 42-day period, it will be deemed that the insurer has accepted the injury that was caused by bullying, harassment, or excessive work demands. Now, importantly, the 42-day timeframe does not start until the worker provides a completed and signed claim form.
Okay, thanks. That's great. Thanks, Matt. Now, these workplace conduct claims, the claims for bullying and harassment and excessive work demands, they will no longer go to the PIC. We know they'll go through the IRC, but up to now, there's been some limited information. So can you tell us a bit more about the types of things that employers can do to assist their claim service provider to make a decision on these claims in the required timeframe?
Sure. So on notification, employers should, if they can, provide the alleged cause of the workplace conduct and or the reasonable management action if it is known. This means where applicable, you should try to provide copies of any internal investigations that have taken place, copies of any relevant documentation that might include emails, letters, meeting notes, warnings, or performance records. Even an outline of management action that was taken and why it was reasonable, as well as the names of any key witnesses. From the worker's perspective, they need to provide the CIRA Workers Compensation Injury Claim Form that will be treated as their statement of events. Again, if the worker is claiming a conduct-based relevant event, the worker must provide the completed claim form before the 42-day timeframe commences. An expedited factual assessment will only be required where material provided is insufficient. The factual investigation will be used to test the worker's account against the employer evidence and that of the witnesses. The expedited factual investigation is designed to assist the insurer to determine whether the conduct occurred and whether it was reasonable management action.
Okay, excellent. Thanks for that, Matt. So moving on to the next step in the process, I think I understand that the IRC will determine the workplace conduct disputes, but can you step us through the process before a claim actually reaches the IRC?
Of course. So yes, you're correct. The IRC will determine conduct-based disputes. As we've just been through, the insurer has 42 days to determine the claim, and that will require collaboration with the CSP, the worker, and of course the employer. If the insurer disputes liability, the worker must request an internal review before it can proceed to the IRC for dispute resolution. There is no time limit for the worker to request the internal review, but once it is lodged, it must be completed within 14 days. There are no extensions available to the timeframe for an internal review to be completed. iCare is standing up a team to conduct the internal reviews for an interim period. The worker will be provided with a dedicated shared inbox address if they wish to request a review of a decision to dispute liability. The internal review team will advise the employer that a request has been received. Now, importantly, the review team cannot manage the claim. They do not arrange investigations or issue new liability notices, and they don't make broader claim decisions. If those actions are required, the internal reviewer will refer those to the CSP.
Okay. So what I understand, Matt, is that employers need to provide information to the CSP or the claims service provider as quickly and completely as they can. Can you tell us a bit more about the significance of the claim form?
Sure. So the regulations stipulate that a relevant conduct claim, so just a reminder, that's bullying, harassment, and excessive work demands, is only made when the worker gives the insurer a completed claim form. This goes back to what I mentioned before about how time doesn't start until that form is received. Now, CIRA have published the claim form on their website along with other collateral. The claim form is 12 pages long. It does gather a lot of information from the worker, including circumstances of the injury and how the conduct is connected to the worker's employment. If an insurer receives an incomplete claim form from a worker, they must contact the worker within 3 business days, explaining that the claim form is incomplete and letting them know what must be done to progress their claim. If a worker does not provide the completed claim form, then their weekly payments and medical entitlements cannot commence under that interim entitlement benefit.
Excellent. Okay, so the IRC is something new in the workers' compensation space. Do we have any more information about what this process will look like?
Yes, we do. So the IRC published their practice note. It's practice note number 38 for workplace conduct claims. That was published on the 6th of July. And this is what we know so far. So the IRC process will start with a worker application. The worker or their representative must submit an application to determine they must submit an application to determine relevant conduct form. That form needs to be accompanied by a copy of the claim made to the insurer, including any annexures that describe the conduct. They need to include a copy of the insurer's internal review decision and any evidence which must be accompanied by a statement. The applicant must serve those documents on the other party or the respondent. The next steps for the respondent are then 7 days after they receive the application, they must enter what's called an appearance. The form must indicate if there are jurisdictional issues, what those jurisdictional issues are, as well as a brief statement around why the claim is disputed. If jurisdictional issues are raised, then any objections to that will be listed for a hearing before a member within 14 days of filing. If there are no jurisdictional issues identified, the matter will be listed for conciliation within 14 days of the application being filed, and that's a really quick turnaround. The conciliation will generally be heard by audio-visual link. The conciliation can be vacated on a joint application by the parties if the Commission considers there are no prospects of resolution. I know that that's a lot of information for everyone to absorb, so bear with me. If there is no resolution at conciliation, the Commissioner will determine any applications made by the applicant to file further evidence. The matter will then be referred to the Registrar for directions. Once the Registrar makes directions, the respondent needs to file a certificate which certifies that there are reasonable prospects of success, and also that the cost of the action in defending the proceedings is proportionate to the claim and the significance of the issues in dispute. Following that, a readiness hearing will be held at least 1 week and no less than 3 weeks before the hearing date. Now, the purpose of the readiness hearing is to identify and resolve any issues that might prevent the matter from being finalised on the hearing date. Evidence will be given by way of signed statements or affidavits with any annexures or exhibits. If a party fails to attend, the matter can be heard and determined in their absence. If an applicant fails to attend a conciliation, a readiness hearing, or a hearing, and does not provide clear and compelling reasons for their non-attendance, then the Commission may dismiss the application. Similarly, if the respondent does not attend, then the Commission may determine the matter in their absence. A certificate of determination may be published by the Commission, and any appeal will be heard by the full bench of the IRC. Importantly, the policy of insurance can't respond unless the insurer and employer concede that relevant conduct has occurred.
Excellent. Thanks for that really comprehensive rundown on the IRC procedures. Now, are you able to walk us through the changes to reasonable management action? And noting there, this is a majority of the questions that we're receiving this morning do relate to this. So I believe there have been some changes to the reasonable management action rules for psychological injuries. What does that involve?
That's right. So as I mentioned earlier, the application of reasonable management action is changing. Previously, it could only be applied if reasonable management action was the whole or predominant cause of the injury. Now it can apply where the reasonable management action was the significant cause of the injury. There's also a focus on whether the management action was objectively reasonable in all the circumstances. So before the worker's perception could be included. Further to that, there's now a broader range of reasonable management actions that can now qualify, which cover more typical management decisions and processes that you see in the workplace. Now, this is the detail that the employers can now qualify. As you can see on the screen, reasonable management action has been expanded from activities such as promotion, demotion, performance appraisal, and dismissal. It now includes everyday management action. So it includes things like performance management and feedback, managing absenteeism, misconduct investigations, any disciplinary action, including suspension, changes to duties or work allocation, addressing any behavioural concerns, and applying workplace policies or procedures.
Excellent. Are you able to tell us about what's not changing in relation to this reasonable management action?
Sure. So the expanded defence under Section 11A does not stop claims. So the worker can still make a claim for psychological injury. The insurer then needs to apply the legislation to determine whether that compensation is payable. Determining whether it was reasonable management action also forms part of consideration in the IRC when determining relevant conduct claims. So for pre-existing conditions, the worker having a pre-existing condition does not exclude them from a potential entitlement. The focus is on how the employer acted, not the medical history. And information required in response to claims, including reasonable management action, needs to be directly relevant to the alleged events, and we need to avoid unnecessary or unrelated material.
Absolutely. So I also understand that there are a number of changes to commutations. Can you provide a bit more information about this?
Yeah, so previously approvals for commutations sat with CIRA. These will now move to the PIC, or the Personal Injury Commission, aligning the process more closely with other dispute pathways. There's also broader access to commutation under the new regulations, and that means that workers may now be eligible to resolve their claim through lump sum arrangements, depending on their circumstances. In terms of eligibility, there are different classes of claims that can be considered. These are in the regulations. It includes workers receiving weekly benefits and medicals, a second category for medical-only cases, and now the third class of claims is those hearing loss claims. The eligibility criteria are quite specific, particularly around injury dates, finalisation of permanent impairment, and whether recent benefits have been paid. So these need to be assessed carefully and on a case-by-case basis. Overall, the takeaway is that there is now greater flexibility and access, but decisions still need to be made with the defined criteria and timeframes.
Excellent. Okay, so Matt, that concludes the formal part of our webinar for today, and has been a lot of really important information provided. I've been looking through the questions, and there have been so many questions received throughout the presentation. Are you okay if we pick through some of these and try to answer them now?
Sure.
Excellent. Okay. Okay, so this one, do the changes to psychological injuries also apply to secondary psychological injuries and claims?
Yeah, that's a good question. And the answer is no. The changes only apply to primary psychological injury claims.
Okay, excellent. With the changes related to the WPI assessments, do they apply to existing claims that are undergoing assessment or only new ones?
Yeah, so this one's a little bit more complex with the transition arrangements in reforms. So the determining factor is the stage of the claim that the claim has reached by the commencement date. So it's not simply the date that the injury has occurred or the date that the claim was lodged. So the changes are not limited to new claims. Existing claims can still be subject to the new assessment process unless they fall within the transitional provisions that preserve the previous arrangements.
Okay, excellent. So looking through, again, a lot of the questions that are coming through are very specific to individual businesses and claims. Unfortunately, as it's a public forum, we're not able to discuss the specifics of your individual claims or policies. But if you do have specific claim-related questions, these are definitely best directed back to your claim service provider. If you have any specific policy-related questions, these can be directed to the iCare policy team, and a link to their contact details will be shared in the post-event pack. As well as they're on your policy document. So if you need to make those specific contacts and ask specific questions, then I would direct you to do so. It's just we're not able to comment on individual claims or circumstances in such a large forum. Another question that we've got here, Matt, is do provisional liability and reasonable excuse still apply to claims other than psychological injury claims?
Yes. So provisional liability and the reasonable excuse provisions continue to apply to non-psychological injury claims, so physical injury claims. Those provisions also continue to apply to psychological injury claims where the relevant event is trauma-based. So they're the ones that result from an act of violence or witnessing a traumatic incident. The main change that we spoke about earlier is the provisional liability and reasonable excuse no longer applies to primary psychological injuries where the relevant event is conduct-based. So those bullying, harassment, and excessive work demand claims now follow those special provisions that I mentioned earlier.
Excellent. Okay. Will there be guidelines published to explain the changes to reasonable and necessary on the 1st of October?
I believe there will be guidelines published by CIRA to explain the changes to reasonable and necessary from 1 October.
Excellent. Okay, thank you. There are also a lot of questions coming through related to premiums and how these are either calculated or impacted by claims. We won't have the opportunity to ask answer these with Matt because he's our subject matter expert on reforms. But I would recommend to anyone at the end of the presentation, use the QR code with links to the Mobile Engagement Team website, because we've recently hosted a series of webinars on how premiums are calculated and how claims may impact and that kind of thing. So it's probably, that's the best source, or also reach out to our premiums team to have those discussions. Okay, so another question that's come up, Matt, is in relation to annual indexation. So has it been decided which month this annual indexation will take place?
Yes, it has. So the indexation will occur on the 1st of April 2027. That will be the first annual indexation that occurs under the changes.
Okay, excellent. Okay, well, there's a lot a lot of questions, but we are going to have to leave it here for now. So I do thank all of you for your attendance at today's webinar. So just a reminder that the recording from the event will be sent to you in the coming weeks and will also be made available on the Mobile Engagement Team website. The links on the screen here, so we have the QR code to the Reforms FAQs webpage. We also have a link to upcoming face-to-face events for the Mobile Engagement Team. So keep an eye out in your emails for the post-event email coming out. And Matt, again, thank you so much for your time and expertise today. And thank you everyone else for your time in attending. Have a great day.
Thanks, everyone.
Thank you.